It is 12:01, so I think I'll go ahead and get started as people continue to sign in here. So good afternoon again. Thank you so much for joining us. I'm Tammy Welty. I'm the Director of Training and Communications at Bradford and Barthel. We have Michael Burns and JP Torres from our San Jose office with us to discuss the going and coming rule. I have Mr. Burns taking the lead today, and Mr. Torres is going to be assisting us with questions. So thank you both for being here. You may have noticed that we're using a new platform. I hope you like it. But just so you can get used to it, I'm sure you've used Zoom before. Most of us have. But the Zoom menu bar, it should be at the bottom of your screen. Please go ahead and find that menu and locate the resources section. I have included several links to our website. The links will take you to different places, including our blogs, our CE training videos, our AMA analysis and rating department, and much more. I've also uploaded a copy of today's PowerPoint presentation and a copy of our 2024 permanent disability money chart. So again, if you find the resources section in your Zoom menu bar, you'll find all of those items. Also in your Zoom menu bar, you're going to find a Q&A section where you can submit questions. JP will be monitoring those questions, as I said, and we will do our best to answer some of these during the presentation. Please show me that you have located that Q&A section by finding it and entering what your dream road trip destination is. So, thank you, Rachel. Rachel said she loves the new look. So go find that Q&A section and tell me what's your dream road trip destination. Okay, so a couple things while you guys are entering that. We are recording today's webinar, and the video will be posted to our training page at bradfordbarthel.com, where you can find over 80 hours of continuing education videos available to you. Today's webinar offers MCLE credit for California attorneys and CE credits for California workers' compensation claims adjusters. Certificates will be emailed to you all this afternoon. Please note that all attendees must be on the webinar, able to see the slide presentation, and attend for the entire hour to receive credit. Unfortunately, we cannot provide credit if you call in on the phone only and are unable to see the slides. Okay, JP, so I want to go to Zion and hike the Narrows. That's what I want to do for my road trip. What about you?
So I was gonna say I don't really like road trips, but that's not 100% true. If they're short, they're fine. I saw somebody also enter that they wanted to go to Big Sur. That is actually close to me, and that's someplace I wanted to try and look at the that famous Bixby Bridge there just to see, because it looked, it's on in movies a lot. So I'm kind of curious.
Awesome. Okay, what about you, Michael?
Well, I've lived in California for 22 years, but I've never been to Yosemite. That would be a great destination. I'd also like to go back to the Florida Keys and go from Key Largo down to Key West and back up.
Nice. I have lived in California my entire life, and I've also never been to Yosemite, so that is sad. But we've
Me
got
neither. So I don't know. Me neither.
Okay, well, we all have to plan a trip. I've got Paris. I don't know if you can do a road trip to Paris. I'm not sure how that would work, but I'd like to hear about it. Italy, Alaska, Colorado, Oregon, Zion. I got another Zion. Yeah, go ahead, married. I love it. Anywhere but work. Okay, I really like Lisa. Her and I need to hang out. A road trip to the Grand Canyon. I just did that for the first time, just in December. And some people are saying Canada, a lot of Grand Canyon, Niagara Falls. That would be awesome. So yeah, thank you guys. It looks like you guys all, Carmel, Vancouver, lots of great things. It looks like you all know how to use that Q&A section. So be sure to submit any real questions that you have in that area at any point during the hour today. We're going to start with some introductions, and then Michael's going to get started. JP, would you like to lead us off?
Yes. So for those of you who don't know me, I'm JP Torres. I'm the managing attorney of Bradford Barthel San Jose office. We primarily handle Salinas, San Jose, of course, and really all venues in the Bay Area, Oakland, San Francisco, some Stockton. Been with the firm, I believe, 6 years, give or take now. If you have any questions, panels, whatever, happy to assist. Please just give us a call or an email, and I'll hand it off to Michael.
Thanks, JP. My name is Michael Burns. I'm a partner in Bradford and Barthel San Jose office. As JP mentioned, we handle cases throughout the greater Bay Area into the Central Valley. I've been with Bradford Barthel for 12 years now, so it'll be my 12th year in July. I greatly enjoy working here and making connections with all of the great clients that we have. And it's a good question about what our favorite road trip would be, because we're talking today about the going and coming rule, which means that employees will be on the road, and what happens when people are going to and coming from work. It's an interesting topic, I believe, because it fits into the overall scheme of California workers' compensation in terms of what is an injury arising out of and in the course of employment. There's the subset that we're going to talk about also, that is the premises liability rule. So that basically is the question of what is the workplace. So today we're going to be talking about what is work. Are we all working right now as we're participating in this webinar? Does it matter where we are physically? Does it matter if we're leaving home and coming back to work? And of course, since the pandemic started in 2020, the work from home phenomenon has been something that's on a lot of adjusters' minds. Many of you may be working from home right now. When does your workday end? When does it begin? So the going and coming rule, sort of as an overview, it's an extremely complex area. It's full of exceptions, sub-exceptions, and you'll find a lot of contradictory opinions when you look at the case law from both from the WCAB as well as from the Court of Appeal. So this is just going to be an overview, and for everything that I may tell you in this case, an applicant attorney or a judge may tell you something entirely different. So you're going to get a lot of different opinions depending on who you talk to and what the particular factual circumstances are. So let's go ahead and get right into it. Sort of as an overview, the California workers' compensation system, as we all know, is designed to provide benefits for injuries that are caused at work, industrial injuries. So as I alluded to, the two fundamental questions that sometimes get overlooked when we run into cases that are sort of on the periphery of workers' comp is, when does work begin and what is a workplace? So these are sort of the fundamental boundaries of workers' comp, the time and the place of work. The legal doctrine addressing the first question of when does work begin is the going and coming rule. When does an employee start work? Does it depend entirely on when they punch in? What if they arrive in the parking lot 10 minutes early? Going and coming from the workplace, either to home or to other venues, either for the benefit of the employer or for personal benefit. These are all of the factors that we're going to be addressing today. The second, what is a workplace, is primarily addressed by the premises liability rule. So that is the question of, well, what if an injury occurs a block from the employer's facility? And you're going to see that in your practice, if you're an attorney, as well as if you're a claims adjuster. You're going to see these cases where it's not strictly located to an injury inside a particular employer's facility. So let's go to sort of an overview of the fundamentals of workers' comp. So workers' comp 101. And to understand the going and coming rule and the premises line rule, we need to first examine the fundamental doctrines of workers' comp, and that is found in Labor Code 3600, that workers' compensation benefits are owed only if the employee sustains an injury arising out of and in the course of employment. So that's AOE, COE, and everyone who's a new adjuster or who has been doing this for 30 years is going to come back to AOE, COE as the fundamental question in most workers' compensation cases. So the fundamentals also include this question or this issue. At the time of the injury, the employee must be performing a service growing out of and incidental to his or her employment and acting within the course of their employment. And the determination of whether an injury is AOE, COE is a two-prong analysis. First, the injury must occur in the course of employment, which ordinarily refers to the time, place, and circumstances under which the injury occurs. And an employee is acting within the course of employment when he or she does all those reasonable things which his contract with his employment expressly or impliedly permits him to do so. And pay attention to that term, impliedly permits. This is going to come up in going and coming cases or in situations. What did the employer allow or tolerate the employees to do in terms of their commutes to and from work? Were they allowed to arrive early or late? Did the employer direct where they would park? And in terms of what the employee's duties are, that's not strictly defined by a job analysis or what the employer says. It's also going to be determined based upon the applicant's testimony, as well as the testimony of coworkers. What did the employer expect these employees to do at work? And the second prong of that analysis is that the injury must arise out of the employment. And that's the causal analysis. So the injury must occur by reason of a condition or incident of employment. In other words, the employment and the injury must be linked in some causal fashion. So there has to be a connection between work and the injury. And as we'll get into later, that is mostly in most situations, a medical determination. For example, did the applicant's carpal tunnel syndrome arise as a result of repetitive job duties? Can the QME explain that sufficiently? That will generally take care of causation. So the summary of what we've talked about so far: only injuries that occur at a time, place, and circumstance relating to work, plus a causal connection between the work duties and the claimed injuries, results in an injury that's covered under workers' comp. And for example, injuries that are occurring outside of the workplace are generally not compensable, subject to many exceptions. And that's usually a factual determination. That's something that will depend upon the applicant's testimony, what the employer says. So it's usually a fact-based question that will be adjudicated at trial. And injuries that are not caused at least 1% by employment are not compensable. And as I alluded to earlier, that's usually a medical determination. In other words, can the QME link the injury to work somehow? It's usually a medical determination, not always, but most of the time. So sort of in conclusion, injuries that are arising out of and in the course of employment are covered. Now, the question that we're going to talk about is, how does the WCAB define the workplace? And that brings us to the going and coming rule. And this is not a rule that you will find in the labor code, but rather it's a judicially created rule that applies to whether an injury arises out of and in the course of employment in situations where employees are traveling to or from work. And of course, it's called the going and coming rule. So injuries that are sustained while an employee is going and coming to and from the place of his or her employment do not typically occur in the course of employment, because while that employee is commuting or going to or coming from work, they're not providing a benefit to the employer, and they're not under the control of the employer during that commute. And this is sort of a common sense understanding. If you ask somebody who's not versed in the workers' compensation system, are you working when you're commuting? Well, I think 99% of people would say, no, I'm commuting. I'm on the road. I'm getting to or going from work. And it makes sense because the employee's decision how and when to get to work is generally something that they are entirely in control of. And it really doesn't benefit the employer one way or the other how they get to work, as long as they're at the workplace on time, ready to work. And I think this quote from the California Supreme Court is appropriate. The going and coming rule has a tortuous history. The rule, which has been criticized and is subject to numerous exceptions, is difficult to apply uniformly and not susceptible to automatic application. No truer words have ever been said in the history of California workers' compensation. That is something that adjusters should keep in mind. When you have a going and coming situation in a case, it's not going to be a black or white answer, no matter how clear you may think it is. Once you delve into some of the cases and some of the bizarre circumstances that some of these cases have addressed, you'd be surprised at what has been found to be a compensable injury, despite the fact that it appears, at least on the surface, that this was a going and coming situation. So that it's very important to remember each case must be judged on its own unique facts. And there is no strict rule in applying the going and coming rule to a particular case. And also keep in mind that the workplace has evolved since a lot of these decisions came down, and we're getting decisions, recently about people working from home and what constitutes the workplace post 2020. And the going and coming rule is riddled with exceptions, and that includes, for example, where the trip that the employee is taking provides an incidental benefit to the employer that is not common to commute trips by ordinary members of the workforce. And that phrase, an incidental benefit, is a tiny little nugget that may be placed on the scale one way or the other in determining whether this is, in fact, an injury covered under California workers' comp. If there's an incidental benefit to the employer, the applicant is definitely going to argue this is an industrial injury. So be careful for applicants that are always going to look for that little tiny benefit that they're providing to the employer to turn what looks like an ordinary commute into an industrial injury. Is the employer benefiting somehow, even incidentally, from the employee's commute? So a sample of exceptions to the going and coming rule, the required vehicle exception. If the employer requires a worker to provide their own transportation as a condition of their employment, then injuries that occur during the commute are compensable. And in the 1972 Hinojosa case, a farm worker was required by the employer to go to different sites during the day, and the court held that those commutes, if an injury occurs during those commutes, it's a compensable injury, despite the fact it is a commute. And the Betts case, there was an express condition of employment for the applicant to use her car between the main office and the job site, and she was paid mileage for that. And she elected to use her car to run other errands, such as the delivery of snacks to her site for the afternoon shift. So that right there, that delivery of snacks, is what we would call the incidental benefit, even though this applicant is using the car for her own personal errands. As long as she's providing some incidental benefit to the employer, such as bringing snacks to the rest of the office, that transforms what would be ordinarily an excluded case or situation, and it brings it now within the purview of AOE-COE. There's also an exception known as the personal comfort doctrine. That's when the employer knowingly allows employees to use their vehicles for the benefit of the employer. Injuries may be compensable. Now, that phrase, for the benefit of the employer, that's going to be interpreted liberally. In my experience with cases that involve the going and coming rule, any incidental benefit that can be placed on the employer will be sufficient or weighed pretty heavily in the applicant's favor. So, for example, bringing snacks to the office, or something as vague as increasing workforce morale, can be argued that that's a benefit that is being provided to the employer. So you'd be surprised what will constitute the applicant's incidental benefit to the employer to bring it within AOE-COE. So the personal comfort doctrine, where an employer condones an employee driving to go get snacks, since that employee frequently brought back snacks or other objects of convenience for the workforce, for employees who remain behind working, this all inured to the employer's benefit. So bringing back snacks to the office, what kind of benefit does that provide to the employer? Not much, in my opinion, but the court found that it was sufficient to constitute a benefit that was being provided to the employer. And it's also important to pay attention to the fact that the court noted that the employer condoned employees going to get snacks. In other words, it wasn't expressly permitted, but the employer knew about it and didn't stop it. That's going to be sufficient to say that the employer is benefiting from the employee's personal use of their car. So we've barely scratched the surface of the going and coming rule. And as you can see, it's full of contradictions, exceptions, sub-exceptions. But generally speaking, sort of to summarize, we have employees commuting to and from work. Those situations generally are not AOE COE. However, a number of exceptions will allow an employee to make the claim, sometimes successfully, that their commute or their transfer to and from the office, whether through public transportation, personal transportation, is somehow benefiting the employer. And I guess to take away from that, when you're analyzing a claim, look for what the applicant is going to argue. They're going to argue that they were providing some benefit to the employer. They're saving them money. They're increasing workforce morale by bringing snacks. Any little incidental benefit that they can argue to bring that case within AOE COE and out of the going and coming rule, they will try to do. So it's important to talk to your employer, get good witness statements, what was permitted and condoned versus what was prohibited. Okay, so that brings us to the second half of our presentation, the premise liability rule. And this is, if you're new in claims, you may not run across this quite frequently. It may take a couple of years before you get a case that involves the premise liability rule. And this is all about location, location, location. An exception to the going and coming rule is the premises line rule. And in this rule, the courts have determined that an employee's commute terminates and the employment or the course of employment begins when they enter the employer's premises. Now, can anyone define an employer's premises clearly? Can they draw a map around it? Well, maybe if it's a Target, you can say it's the particular store, or if it's a Subway restaurant, it's the particular restaurant. But you'd be surprised at some of the exceptions to the premise liability rule and how the actual line that defines the workplace has been expanded quite significantly. So the basis for extending the employer's premises to include things such as driveways, parking lots, approaches to roads, approaches and roads leading to the employer's premises is found in the fact that the employer exercises some sort of control over those areas and that it's necessary for the employees to use them for ingress and egress. Getting to and from the actual place where the work is done requires the employees to get to the parking lot or go across a road to get there. So when you're looking at a premise liability case, you're looking at, number one, what does the employer have control over? And number two, what does the employee have to do to actually get to work? If an employee works on the 10th floor of a building, they have to go in the entrance, they have to go up the stairs or the elevator. So the workplace is not specifically defined by, four walls and a door. It's oftentimes much broader than that. So going into the premise liability rule, after entry onto the employer's premises, so once the employee sets foot onto the employer's premises, any injuries that are sustained there are presumed compensable as arising in the course of employment. They're at the actual workplace facility. Injuries that occur there are generally going to be presumed compensable. And if you're in claims, you're going to run across very frustrated employers that don't understand that just because an employee is susceptible to a particular injury, the fact that it occurs inside the actual workplace within those four walls 99% of the time, you're facing an uphill battle and proving that it was not an injury that was sustained at work and not arising in the course of employment. And the flip side of that is once the employee leaves the premises, injuries sustained during the commute home are generally non-compensable. That also brings me to think of situations where an employee will either sustain an injury or perhaps pass away at home, and you'll have a claim that, well, workplace stress caused the heart attack or the stroke at home. So just because an injury occurs at home or away from the workplace does not automatically bring an injury outside of the course of employment.
Hey, Michael, we have an interesting question from David. Now, what if an employee is injured on the employer's premises, but that employee was not scheduled to be working that day?
We're going to get to that. There are some interesting cases that have arisen from employees who are at the employer's facility when they're not supposed to be there. In one of those situations, the WCAB held that an employee who returned to the employer's facility after hours, but she had a key card to get in, she went in because she forgot her purse. So she went back later that night, 9 or 10 o'clock at night, to get her purse, and she was assaulted either inside the building or in the parking lot. I forget the exact situation, but the WCAB held that this was not a compensable injury just because it occurred at work. It was well after the employer had closed the facility. She wasn't scheduled to be there. She wasn't expected to be there. The employer had given her a key card to get in, which technically she could get in at any time of the day or night, but it was not in the course of employment. She was not working during that time. So that's a good question, and you're probably going to see that a lot, especially in situations with white-collar workers where they have an office and they can go to the office anytime they want, really, as long as they have the keys to get in. If they want to work on the weekend, they can go into the office, get whatever they need and leave. It's going to also come down to what does the employer expect and what is condoned. If the employer gives a white-collar worker on Friday afternoon a project that's due on Monday, there may be the expectation that they will be in the office that weekend, they will be working, and that may be sufficient for that applicant to argue that I was expected to be there. The employer gave me no real other choice than to actually go to the office. So that can take a weekend injury and bring it into AOE, COE, industrial injury. Very good question. Now, as we mentioned before, punching in and punching out is not as defined as we may think. Just because an employee has ended their workday and punched out, they're not in their commute yet. They're still in the transition period from ending work to going home. So this is generally what we're talking about when we talk about the premise liability rule, the walk to the car or to the bus stop. The commute hasn't begun yet, but it's about to. So the premise liability rule can be sort of summarized as follows. The employee's travel between the workstation and the point of entry to the employer's premises is a reasonable margin of time and space that constitutes the employer's premises. So just because an employee is not at their desk and they're making that transition period to or from their car into the front, perhaps past the reception desk and up to the office, that is considered within the employer's control. It's on their premises, even though it's not technically. So in other words, there's not a sharp, hardline rule to when and where employment begins, but rather the employees are covered under workers' comp during a reasonable distance and time before and after leaving the employer's premises. So an employee who works at Walmart may punch out at 5 p.m. It's going to take them 10 minutes to either gather their belongings from their locker, say goodbye to their coworkers, walk out even to get to the parking lot. And then once the parking lot, it may take another 4 or 5 minutes to get to the car and leave. This is all that gray area that generally speaking is going to constitute the course of employment. This is still the workday, despite the fact work has stopped. So injuries that are sustained by an employee while going to or from his place of work upon premises that are owned or controlled by the employer are generally deemed to have arisen out of and in the course of employment. So just what I mentioned before, the fact that the employee has punched out and they're not working anymore does not automatically mean that an injury sustained on the way out of the facility or even in the parking lot, getting in the car is going to be not covered under workers' comp. In other words, don't jump to conclusions just because an employee has ended their work day by punching out. So the premise liability rule, injuries that are sustained in close proximity to the employer's premises may in fact arise out of their employment, especially when the accident occurs in the parking lot used by employees or on a public property immediately adjacent to the workplace. And when you're analyzing these claims, the closer you get to the workplace, the higher the likelihood is that it's going to be found industrial. An injury that occurs 10 blocks away from the employer's facility likely is that applicant is going to have a hard time trying to make the case that this was an industrial injury. If it occurs a block away while they're leaving their car or going to their car to get something, is a higher likelihood that this will be found industrial. So it's again important to keep in mind that this rule means that there's a reasonable margin of time and space that is to be used in passing to and from the place where work is to be done. So if you think about this, think of 3 concentric circles. In the center, you have the actual working day, 9 to 5. The employee is at their desk or at their workstation. Then outside of that, you have this gray area that's this reasonable margin of time and space. And then outside of that, you have the non-working day. It's that gray area that's going to be covered under the premise liability rule. So some examples: injuries in the employer's parking lot or in a nearby lot or street parking, if there is no employee lot, are generally found to be compensable. Why is that? That's because the employer has some degree of control over the parking lot or where employees are expected or condoned to park. It's also important to keep in mind that, as we've mentioned before, it's not just what the employer expressly allows, it's what they're condoning or what they're overlooking. There's also a case finding, that was the Price case, finding that the injury occurred in the course of employment and was compensable when this employee was injured outside of the workplace while changing the oil in his car and waiting to be admitted to work. So work hadn't even begun yet. He was there a little bit early, waiting for the place to open up. He decided to change his oil in his car, was injured. I think another car sideswiped and hit him. And that was found to be sufficient to support an industrial injury. There's also a case where the applicant was instructed by the employer to park in a lot across the street from his workplace, and while crossing the street, they got injured. So the employer in that case was exercising some degree of control over where the employee parked. The other case involved a retail store manager's injury when she fell after leaving the store and exiting within the confines of the mall and walking towards the parking structure. So she had left the actual store where she was employed, but she was still walking through the mall to get to her car. The injury that occurred in the mall was found to be industrial. Sounds kind of unfair, and it kind of is for employers and for insurers, but this is that gray area that you need to be aware of.
And Michael, we have another question here, an interesting one. Now, what about the situation where the an employee, presumably an hourly employee, has clocked out but is on an employer-provided shuttle, and then injury happens on that employer-provided shuttle?
I think you can probably surmise that that's probably going to be found industrial. Why? the employer shuttle is just that. It's the employer's shuttle that they have control over. They have control over the time and the place where it goes. So even though they're clocked out, I would say that the fact that they're on this shuttle, they're still within the employer's purview and within the workplace. They have not begun their commute yet. Therefore, I don't think the going and coming rule would exclude their claim. Very good question. So with that in mind, what kind of spurred my interest in the premise liability rule was the recent case from 2023 of Jones versus Regents of the University of California. So in that case, this was a Court of Appeal decision that held that the workers' compensation system is the exclusive remedy for this employee that was injured on a bicycle while traveling home from work. So this applicant worked at the University of California, and she ended her workday and left her office at the science library, and she walked a short distance with her bike to a bike path, got on the bike and began riding home. And about 10 seconds later, while she was still on the campus, she reached a trench surrounded by caution tape, swerved, attempted to brake, but fell off her bike and sustained injuries. So she sues the University of California, alleging a tort claim, negligence and premises liability. And the university said, no, you can't come in civil court for this. You have to go to the workers' comp system. The Court of Appeal agreed and said that, yes, this was a workers' compensation case, not a tort case. And their reasoning was that the injury occurred on the university's campus, even though she had left her actual workplace. And the campus was undisputedly owned by the university. And importantly, it was immediately after she left her workstation. So again, location, location, location. The land where she was injured was owned and controlled by the university. And it's important also that the time played a factor. It was immediately after she left her workstation. A question may arise, well, what if she had clocked out, taken her bike and gone to maybe a coffee shop on the campus for 2 hours, then gets on her bike and then is injured on the campus property while going home. I would argue that that takes it out of the employer's premises and takes it out of AOE COE because there was such a delay between the time she actually clocked out and was done with the workday and the time she began her commute home, despite the fact it was still on the employer's premises. So there are two ways to look at all of these premise liability cases. We're talking about a lot of gray area. So in the Jones case, they talked about a 1941 case, Smith versus the Industrial Accident Commission. And in that case, an injury occurred while the applicant, the employee, was traveling on a ferry terminal on the way home from work. And the reason they were on a ferry was because the employer was located on an island that was all under their control. And despite the fact that the ferry was not controlled or operated by the employer, the premise line rule supported the conclusion that the injury was industrial. How else was the employees expected to get to the work site except for taking this ferry? And that goes back to maybe the question that we had a few minutes ago, if they're on an employer provided shuttle. Yes, I think you're going to find that that's an industrial injury. So look at situations where an employee has no choice but to go a particular route to work or take a particular form of transportation, that they're going to argue that any injury occurred during that commute is industrial because they had no other way to get to the actual workplace or the work facility. So is the employer's location difficult to get to? That's something you should keep in mind. So in the Jones case, the 2023 case, like Smith, the employee was leaving work rather than arriving. And both employees traveled by the means of their own choice on roads that were used by non-employees as well as employees. So they're on a public road, just like in Smith, they were on a public ferry. And the employer's premises in Jones was expansive. It was a university campus. So the trial court implied an objective and fair boundary as to where the employer's premises began. They're not required to draw a sharp line. So in cases that involve large employers, large facilities, you're not going to have a sharp line. This is the workplace. This is outside of the workplace. There's going to be that gray area. Big college campus will have big boundaries. Think about also in an office. Well, what is the employer's facility? Is it just the particular suite that they occupy? Is it the area outside of the suite, the public restrooms that other offices can use? Is it in the elevator? Most likely that's going to be found to be part of the employer's premises as well. Company vehicles. This is interesting. If the employer provides the employee with a company vehicle, injuries sustained while driving to and from work are generally compensable. And this is called the vehicle use exception. This is where the employer provides the employee with a vehicle and requires it to be used as an incident of employment. So the company vehicle. Evidence that supports a company vehicle exception to the going and coming rule. And it's easy to get confused. We're talking about exceptions to a rule that is an exception to AOE, COE. If it's confusing for people, just think of company vehicles as bringing people within the workers' comp system. So where an employer furnishes a vehicle to the employee for the purpose of transporting himself to and from work, and where the vehicle is ultimately under the employer's control, that's a company vehicle. Some additional evidence that would support the finding that there is a company vehicle. Does the employer own the vehicle, pay for the insurance, pay for the maintenance and fuel? And do they require the employee to drive the vehicle as part of their work duties? You'll see this a lot in situations involving salespeople, even janitors that have to go clean multiple office locations or facilities in an evening. They have to have a car. It may be a car that's provided by the employer. They're expected to use that car to get to different locations. Even though they are not paying for the car, it's maintenance and insurance, that still will support the finding that that's a company vehicle, and injuries sustained during the commute will be generally presumed compensable. Not all the time, though. Let's think about affirmative defenses to the company vehicle rule. Injuries that arise out of an employee's use of a company vehicle for purely personal reasons, or where the employee takes a material deviation, are not compensable. So again, if the employee has a company vehicle and they decide to go to Disneyland or take their kids on a trip, that's not going to be an industrial injury, despite the fact that they're physically in a company vehicle. But thinking back to what we talked about earlier, what will the applicant respond when faced with that pushback? They're probably going to say, well, even though I took a slight deviation, I was still providing a benefit to the employer. For example, I was saving them money, or I was improving employee morale. Whatever the case may be, they will push back and they will say that they're providing some sort of benefit, even though they're taking a material deviation in the company vehicle. So, questions that claims professionals should think of when looking at company vehicle injuries. Is there any express provision in the employee handbook or any HR documentation that prohibits the employees from using the company vehicles for purely personal errands? And are the employees actually disciplined for violating this rule? You may have a rule against something if it's overlooked either implicitly or explicitly by the employer. The WCAB trial judge may find that it's not a rule at all. The employer was condoning the employees to use the vehicles for purely personal Starbucks runs or to go shopping in. So there has to be documentation that supports the employer's prohibition against using the vehicle for purely personal reasons. The claims adjuster should also look at, and the attorney should also look at, what evidence shows that the trip was for purely personal reasons. the applicant's testimony, what they may have told coworkers, text messages, when an injury occurs in a company vehicle, what evidence surrounding that injury can bring that case out of the company vehicle exception to help the defense show that it was not an industrial injury. Don't overlook the possibility of intoxication, which is its own affirmative defense, but that's something that should certainly be looked at as well. So the takeaway to the going, oh, yes, we have.
Michael, we had two
question.
similar questions, somewhat related to both going and coming as well as the premises liability. What if the office building has a gym, for example, available for the employee use, and the employee is injured on that gym, presumably during off hours use of a gym on site? How does that affect compensability?
Generally, with gyms, as with situations involving employer kitchens or lunch areas or other areas that are provided for the benefit of the employee, you're generally, during the work hours, those are going to be found industrial injuries. An employee who is on a lunch break, clocked out, and is in the lunchroom, burns themselves with something or slips and falls, that's going to be an industrial injury, even though they're on their lunch break, because they're in the facility controlled by the employer. If they're in the gym at 3 o'clock on a Sunday when they're not expected to be there or work, I'd say generally no, that's not going to be industrial. That's not the end of the story. They're probably going to argue, I was expected to work that weekend, or the employer knew that all the employees would come in on the weekend to use the gym because we were so stressed out from work that the employer knew that if we used the gym, we'd be more productive during the week. You'll see any kind of argument that you can think of to bring that in as an industrial claim. I would say there should be something in the employer handbook or HR documents regarding non-working hour use of the employer's facilities. And if that is prohibited, then I think that can be persuasive to say that this was not during a time that the employer exercised any control over that facility.
And one more question that is quite interesting. Now, would a denial of the workers' compensation claim, presumably during going and coming, would that open up civil liability? Meaning, would the employer then be able to sue their employer civilly if the claim is denied in comp?
Yes, I would think so. That would be the employee. Somebody's going to end up paying, and it's either going to be in the workers' compensation system or the employee is going to file a civil claim. Presumably, if it's during a commute and there's a car accident, it's going to be against the other driver. It may be against the employer for whatever negligent theory they can think of. But yes, I think it potentially would open that up. Of course, depending on the facts of the case. But generally, yeah. The takeaways. So sort of as a summary, what can we think of? Well, evaluating the physical area where an injury occurs and the time that the injury occurs is important, like the gym question. Where did it occur? Well, it occurred in the gym, but was it during the time that the employee was expected to be there, or were they expressly prohibited from being at the facility at that time? So location and time. And claims professionals should not immediately conclude that an injury is compensable or non-compensable based upon the physical location where the injury occurred. You need to gather the evidence, take the time, talk to the employer, talk to the other employees, figure out what was accepted or condoned by the employer. Some injuries that occur outside of the employer's facility may be industrial. So for example, where employees are required to pass through a particular public point of ingress or egress to the facility. The injuries that occur in that location may be industrial. The accepted customs or habits of the employer or employees may result in a more broad definition of the employer's facility. What does the employer allow? So another takeaway, an employer that allows employees to congregate outside of the facility may be liable in workers' comp when an injury occurs before the facility is opened. Same as the man who is changing his oil, waiting for the facility to open up. And you may say, well, the employer prohibited that. Well, was this prohibition actually enforced, or was it overlooked by the employer? So the going and coming rule, a takeaway to bear in mind, an injury may not be industrial if an employee unreasonably loiters after his or her workday is completed and they are expected to leave. Or conversely, if they return to the employer's facility later that night, to retrieve a purse, they're not expected to be there. They're not expected to stay at the employer's facility for an hour after the workday ends. What is reasonable will be determined by the expectations that are set by the employer, as well as in training materials, employee handbooks, and testimony. What will other employees say about what the employer expected or tolerated? So in evaluating what may look like a questionable claim that may involve going and coming or premise liability, the claims professional should carefully review witness statements, employee training materials, the habits and customs of the employees and the employer, and perhaps a site inspection to determine what is the physical layout of the employer's facility. Picture is worth 1,000 words. Final takeaway here, taken together, these tools can assist the insurer in determining compensability when injuries occur outside of the employer's premises or outside of during the workplace, during the commute to and from the workplace. So again, it's important, what do the documents say? What does the employer say? What do other employees say about where the workplace is? When does work begin? What is expected of the employees, either during their commutes or if they have a company vehicle. So these are very fact-sensitive situations. And to go back to what the WCAB said, the going and coming rule has a torturous history. It's complex, it's fact-determined, fact-sensitive, and no two cases are alike. That brings us to the end. I appreciate everyone who logged on today and for all the great questions that we had.
Thank you, Michael. We did finish a couple of minutes early, so that's a good opportunity to pull up a selected couple of questions. Unfortunately, we had a lot of good questions, so we won't be able to get them all, but there were a couple of ones that I think I'm getting either multiple iterations or I think is just quite interesting. The first one, a little bit of going and coming as well as premises liability. Hypothetically, we have a truck driver, one of these long haul type truck drivers, who is driving, but during his off hours, asleep in his truck, has a stroke. What do you think of that one, Michael?
Again, it could cut either way. I would think the applicant would argue that the fact that they're sleeping in the truck means that they're still within the employer's control. What is expected of the employee in that situation? Are they expected to be in the truck? Does the employer want them to be in the truck spending the night there? If so, they're going to argue that they're still working while they are physically living in that truck. And that goes back to the bunkhouse rule. And that's a whole other can of worms to open up. But I would say, look at what is expected of the employee. Are they supposed to be there? Are they not expected to sleep in the cab? Or are they required? Is there some requirement that they stay with the truck during the night? It's going to depend on a lot of facts and a lot of digging, I think.
Thank you. And we had an interesting couple of questions here. If an employee is hourly versus salary, does that affect any of these discussions we talked about?
I think for hourly employees, it's easier to determine when the workday begins and ends. As we were talking about earlier, punching in and punching out gives you an idea as to when the workday ends, but that is not the be-all end-all. There is that gray area before and after the employee punches in and punches out, that there's still going to be considered working for workers' comp questions and injuries. For salaried employees, I think that there's a lot of potential for work from home injuries, people that may be working on the weekends. They're not making an hourly salary, but they're rather not making an hourly wage, but they're earning a salary, that they're expected to be working or available on call all hours of the day. You do have some cases that involve people getting phone calls at night, working at home, and then trying to claim, well, I was working when this occurred. It's going to go back to, I think, what I touched on earlier. What did the employer expect? What did they require the employee to do? And what, on the other hand, what did the employee elect to do on their own, of their own volition, in terms of either working from home, taking work home, working on the weekends, being at a facility when they're not expected to be at the facility? How much of it is determined by their own independent course of action versus what the employer expected them to do? So I think that's going to be very important.
All right, great. And we still have a lot of very interesting questions. Unfortunately, we've sort of run out of time, and I think there might have been some closing remarks. So I'll pass it back to Tammy.
Yeah, thank you. Fascinating topic. Thank you so much, Michael. That was fantastic. I just want to mention that we have scheduled our March, April, and May webinars. You can register for them now on our training page on our website at bradfordbarthel.com. Our March 19th webinar is going to be with Greg Fletcher on how to prepare a compromise and release. So don't miss out on that. Certificates for all of you, MCLE and CE, will be sent out this afternoon, I promise. And we appreciate you joining us. We look forward to seeing you all next month. Thank you so much, everyone. Have a great rest of your week.